I think you're live now.
Okay. You still got 2 minutes to go.
Okay.
Thank you.
Yep.
Yeah. I get it. Folks around the chairs over behind the big screen. Next to it. Betsy Coes, myself, Kevin Lawrence, Steve Vievich, and Catherine Tarnowski is an alternate, acting as a member this evening. We are here as a meeting, first off, to determine whether the Zoning Board of Adjustment has jurisdiction over the appeal that is filed. Under the RSA 676:5, it puts into, all right, yeah. Section B, the decision of an administrative officer includes decisions including construction, interpretation, or application of the terms of the ordinance. It does not include a discretionary decision to commence formal or informal enforcement proceedings. But it does include any construction, interpretation, or application of the terms of the ordinance, which is implicated in such enforcement proceedings. So on this statutory definition of what the zoning board can do, there is some apparency that this case doesn't belong here. This is a meeting at this point, so this hasn't been formally accepted. I'm going to give the applicant's or appealant's attorney a moment to try and describe with the board how he feels the board does have authority to act in this case.
Thank you, Mr. Chairman, members of the board. My name is Tom Gilbert, attorney of the Plain Citizen, representing 3 neighbors to the Vernon Farm. And Garrett was kind enough to tell me this would be a threshold issue, and frankly, it's the 3rd page of my papers that I brought with me tonight because I knew it was coming.
Yeah.
And in fact, as I thought about this, I was reminded of the fellow who was running across the road in 1992, started his debate with who am I, why am I here? So you may remember that. Let me step back for a second. One of the reasons that we're here, I think, is feedback that the system isn't working. The Vernon Family Farm has been before boards in town for 10 years, and there doesn't seem to be any end in sight. And everyone's frustrated by that. The Vernon's unsure. The neighbors are, I know they are. I'm sure the volunteer members of the board are frustrated, members of the public who are interested in one side or the other. And it all boils down to, or not all of it, but much of it boils down to this hard to pin down definition of agritourism. So when we first got involved in this case in May, not that long ago, our clients had all 3 already written letters to the select board saying we have continuing concerns about how this is operating, conditions are not being complied with, so forth. And they hired us, and we wrote a kind of a wraparound letter that buttressed their 3 letters, and we specifically asked the select board to issue a cease and desist order. We were seeking them to exercise their authority as the enforcing board in town to suspend the operations until the conditions of the site plan approval had been fulfilled. I wasn't at that meeting, a colleague of mine was, but I read the minutes, And I think I could paraphrase by saying this: bottom line, they took no action. The Board of Selectmen took no action. They heard from our clients, they heard from my colleague, they heard from the Vernon Family Farm attorney. There was some discussion about the fact that agritourism remains this elusive concept that we can't define. I think the chairman of the board urged people who had a beef with that fact to write to their representatives in Con to have them solve the problem. And at the end of the meeting, the minutes reflect that it kind of petered out with the select board simply saying, we're going to keep an eye on things. I think Amy Manzelli, attorney for Vernon Family Farm, had represented that they were actively working on fulfilling the conditions of approval of the site plan. And the select board seemed to be in there taking no action. They didn't take a vote. There wasn't a motion. It was not decided. They certainly didn't do what we asked them to do. But they listened to our concerns. And I can't ask this board, under the statutory section the chair read, to take on directly that ask and refusal. The request for the cease and desist and refusal to grant it. But there is that second part of the statute that says this board can hear appeals of actions by administrative boards, including the Board of Selectmen, where their decision, if you will, in this case a decision not to take action, is predicated on an erroneous interpretation of the zoning ordinance. And there are two aspects that I want to bring to your attention if you'll accept jurisdiction and hear our case. One concerns the kind of fundamental rights of any farm to conduct so-called agritourism events in the absence of planning board site plan approval in the RA zone. So this would require you to grapple with the decision of what kinds of uses are embraced by right and would not require any kind of municipal review or approval, including site plan. And I think that the evidence would show that without a site plan review, a farm in the RA zone cannot engage in such uses. Places in the record where the planning board said expressly that. There was a precedent decision involving a winery in town in 2014, where that decision was also made. So that's one aspect that I think involves interpretation. And the other one involves kind of compelling the selectmen or compelling the planning board or asking this board to wrestle to ground some working definition of agritourism, some definition of restaurant. The town's zoning ordinance incorporates the concept of agritourism by reference to the state statute. And it seems to me it's incumbent on the town land use boards that are enforcing that town adopted zoning ordinance not to punt on that issue, but to take a firm stand and take enforcement actions for it. So those are the two domains where I think that there's, we can talk about those definitional issues. And at the end of the day, if I had my way, this board would make a decision to the effect that the select board, if you thought that the Vernon Family Farm could conduct events when its conditions of the site plan are not fulfilled, you were mistaken, because our ordinance doesn't permit those uses except with the full site plan approval, not just conditional, but fully compliant. And then secondarily, if you believe that what the Vernon Family Farm is doing on the property in terms of meal service, beverage service, constitutes a restaurant, then they don't have this board's zoning variance approval to conduct that operation. Again, that kind of forces them to grapple with the definition of what kind of meals may be served under the agritourism umbrella versus where is the line drawn and tips over into the restaurant. And again, the evidence would show that at different places in the record, Mr. Vernon himself has contemplated, I have a restaurant on my property. At least in the minutes, that will reflect that. But you'll also see, if you read the minutes of the planning board decisions leading up to their December 2002 site plan approval, that there were about half a dozen definitions of restaurant suggested in the course of the conversation, and the planning board never settled on one. So those are the definitions. But I also would say, because it's hot, and I'd rather be elsewhere, that if you guys said you don't have jurisdiction, fine by me. This is not the last stop on the train. Our recourse next week will be a petition for mandamus with the Superior Court, asking for the order to compel the selectmen to enforce the decision from the ordinance. There's a private civil action that's going to be brought against the Vernon Family Farm by the neighbors for recurring trespass and the noise that comes onto their property. We're looking at the submissions that give rise to liquor licenses and food licenses. Because we believe that misrepresentations made to state agencies in procuring those licenses. So this is a brief visit on the lawn journey. And we're here in part because it's a conservative move by a lawyer to assume that some action taken by a tribunal, especially when you've asked for it, is a decision, and if you don't appeal it within a statutory time frame, you may be accepting a conclusion that will come back to you. So that's my pitch on the subject.
Thank you.
Thank you.
So discussion amongst the boards about approving or denying hearing this appeal. A few notes that I have is that at the planning board level, there were 30-day appeal periods, and it was not brought to us at those times. The select board on town incursions to the neighbors. That's something I don't know the answer to, but I suspect it could be ongoing with their determination of how to deal with that. The council has certainly got it right on that agritourism is not well defined at the state level. I happened to have been close with one of the representatives at the time, and I described to her that this was going to be an incredible burden on communities. Here we are this evening. Consider this a burden. Does anybody else on the board have something to say about this?
Yes, as I read 676, column 5, we don't have jurisdiction over a decision or non-decision in this particular case. Because 676.5 doesn't include discretionary decision to commence formal enforcement hearings. The select board decided not to act.
That's a discretion.
And I would agree, it doesn't represent an error in interpretation of an order or a decision or an ordinance. And that it would be within our jurisdiction to hear the appeal.
I agree that we don't have jurisdiction as cited by
676 Glen.
In that case, I'll make a motion that the ZBA does not have the authority to hear the appeal of administrative decision applied for this evening against the Board of Selectmen by Attorney Hilbert.
Second.
All in favor of denying this appeal, say aye.
Aye.
Aye. So that concludes part about whether we have jurisdiction. There are other sections in our handbook that I had discovered to reinforce some parts of that. This is a sticky wicket, sometimes called. It's an awful big thing for 5 people sitting in a community to have put on. There are some good, certainly some good points that are brought out in your application, and I wish you well in your pursuit. Okay, so that was what we had on our agenda this evening. If we would make a motion, I see no other business this evening.
You need a motion to adjourn?
Yep.
Or close the meeting?
Yes,
Close the discussion.
we close the meeting.
Okay, close the meeting.
That's your motion?
Yes.
Second. All in favor, say aye.
Aye.
Well, folks, that's so much that my method. Thank you all for coming.
Thank you all.
Thank you.